Defending a murder case in court is a complex legal process that requires careful strategy, thorough preparation, and expertise in criminal law, and serious undertaking that requires legal expertise, thorough preparation, and a strategic approach. If you find yourself in this situation, it's crucial to seek professional legal counsel immediately. Here are some general steps that a defense attorney might take. 1. Understand the case. Analyze all available evidence, witness statements, and documentation related to the case. Understand the prosecution's theory of the crime and identify potential weaknesses or inconsistencies in their case. 2. Build a strong defense. Develop a solid defense strategy based on the evidence and facts. Consider potential defenses such as self-defense, alibi, mistaken identity, insanity, or lack of intent. 3. Interview witnesses. Identify and interview potential witnesses, both favorable and unfavorable to your client. Obtain statements that can support your defense and challenge the prosecution's case. 4. Investigate the case. Thoroughly investigate the facts and circumstances surrounding the alleged murder. This may involve reviewing evidence, interviewing witnesses, and gathering information that could support your defense. 5. Investigate the crime scene. Conduct a thorough investigation of the crime scene to gather any physical evidence that could support your defense. This might involve collaborating with experts such as forensic specialists. 6. Develop a defense strategy. Based on the evidence and circumstances, your attorney will develop a defense strategy that could include arguments such as self-defense, mistaken identity, lack of intent, alibi, or challenging the credibility of witnesses. 7. Expert witnesses. Depending on the circumstances, your defense may involve expert witnesses such as forensic experts, medical professionals, or psychologists who can provide specialized insights that support your case. 8. Cross-examination. Prepare for cross-examination of prosecution witnesses. Focus on inconsistencies, contradictions, and any information that might weaken their credibility. 9. Challenge evidence. Scrutinize the prosecution's evidence, including physical evidence, witness statements, and expert testimony. Look for weaknesses, gaps, or alternate explanations. 10. Present alternate theory. If possible, present an alternative theory of the crime that raises reasonable doubt about your client's guilt. This might involve suggesting other suspects, exploring motive, or proposing alternative timelines. 11. Gather character witnesses. If relevant, gather character witnesses who can testify to your client's good character or provide an alibi. 12. Prepare your client. Prepare your client for trial. Ensure they understand the legal process, potential outcomes, and what to expect during cross-examination. 13. Negotiate with prosecution. In some cases, your attorney may engage in plea negotiations with the prosecution to seek a lesser charge or reduced sentence. 14. Preparation for trial. If the case goes to trial, your attorney will prepare for court proceedings, including selecting a jury, if applicable, preparing opening and closing statements, and questioning witnesses. 15. Presenting the defense. Your attorney will present your defense, cross-examine prosecution witnesses, and present evidence that supports your version of events. 16. Closing arguments. Your attorney will make a closing argument summarizing your defense and highlighting any weaknesses in the prosecution's case. 17. Jury deliberations. If your case goes to trial, the jury will deliberate and reach a verdict. Your attorney's role is to advocate for your innocence and ensure your rights are protected throughout the process. 18. Craft opening and closing statements. Develop compelling opening and closing statements that outline your defense strategy, highlight the evidence, and challenge the prosecution's case. 19. Courtroom etiquette. Maintain professionalism in the courtroom. Respect the judge, jurors, and opposing counsel. Present your arguments clearly and logically. 20. Anticipate objections. Be prepared for objections from the prosecution. Anticipate potential objections during witness examination and responses to your arguments. 21. Stay adaptable. Be ready to adapt your strategy based on the unfolding trial. New evidence or developments might require adjustments to your defense approach. 22. Maintain confidentiality. Respect client confidentiality and adhere to ethical guidelines throughout the defense process. 23. Suppression of evidence. If evidence was obtained illegally or in violation of your rights, your attorney may file motions to have that evidence suppressed, which could weaken the prosecution's case. 24. Hire an experienced attorney. Choose an experienced criminal defense attorney with a strong background in handling murder cases. They will guide you through the legal process and develop a defense strategy tailored to your specific case. 25. Legal research. Your attorney will research relevant laws, precedents, and court rulings to build a solid legal argument that supports your defense strategy. 26. Appeal options. If the verdict is not favorable, be prepared to explore appeal options, focusing on any legal errors during the trial. Remember that each murder case is unique, and the defense strategy will depend on the specific circumstances, evidence, and legal considerations. It's imperative to work closely with a qualified defense attorney who can provide you with appropriate guidance and representation throughout the legal proceedings.